Any adjournment request?
Lord, for listing, my lord, tomorrow, my lord. Urgent.
Motion.
Urgent.
Motion.
Motion.
What is the
Tomorrow.
subject?
Subject eviction.
Okay.
My lord, I
How
am
like
also
it?
having similar prayer, my lord, eviction matter. Eviction matter may be taken up.
Eviction.
My lord, I have also similar prayer, but admission matter, any date in next week, my lord.
Next week. Give it to court now.
Please, with your lordship, I beg to mention item number 12. Your lordship. With the consent of the other side, it may be taken up after a week.
Date may be fixed, lordship.
After. Who is for your father?
Petitioner
Miss
H. Jain.
Jane. Okay, on the prayer of Miss Jane, learning council for the petitioner. With the consent of Miss
And Kakoti, lordship.
Ann Kakoti. You're for whom?
GST, lordship.
You're standing council.
No, lordship. On behalf of SCK, lordship.
Okay. Come and list the case after a week.
Obviously.
Lordship, I beg to mention for listing of a petition, Lordship. On
Subject?
Monday next, Lordship.
Subject?
Subject regarding to land sale transfer, Lordship. Land sale transfer, Lordship.
Which column?
Lordship admission column.
Give it to the court master. He'll give that it.
May please, your lordship. Yes. Same matter, lordship. My subject matter is regarding eviction.
Motion.
No, my orders.
Give it to the court master.
May it please lordship. Lordship, I beg to mention two writ petition for listing.
What is the subject?
Lordship, land acquisition. Land acquisition.
Land acquisition.
Lordship.
May I please, lordship, may I beg to mention for listing? Motion.
What?
Listing for listing.
I'm not hearing you.
For listing.
What is the subject matter of the petition?
Land acquisition.
Land acquisition.
Yes.
May I please, your lordship? My lord, my shop, my lord, has been seized by not following the due procedure of law and under the Cattle Preservation Act, suspecting sale of some objectionable meat item, my lord. My lord, this is my only livelihood, praying for tomorrow, my lord.
Motion.
Motion, my lord.
Friday? Already.
My lord. Then, my lord, another eviction matter, my lord. Eviction
Motion.
matter. Motion, my lord.
When? Tomorrow or Friday?
If my lord allows tomorrow, my lord.
Friday?
My lord, actually, the
Time
notice.
period is over.
Time period is today is going to be over, my lord. Tomorrow morning they may come for demolition, my lord.
Okay.
There is an update. My lord. Obliged, my lord.
Lordship, with the consent of the other side, I beg to mention item number 3, Lord.
Yes.
Lordship.
Oh, it will read not 12 for mention memo circulated will give. Okay. Mr.
W. Rohan on behalf of Mr. A. Sharma.
W. Rahman. Under W. Rahman, the council, on behalf of Mr. A. Sharma, learned council for the petition, has made a prayer for adjournment of the case for 2 weeks.
Lordship, I'm praying for a fixed date, Lordship. Can it be on the
For
first
2
week
weeks.
of the
For 2
December?
weeks.
Lordship?
2000 for 2 weeks. Okay. It is.
Lordship,
prayer
can we
is
get a
made.
date?
Prayer is made with the consent of the learned council for the respondents. Mention memo to that effect or has also been circulated yesterday. Those were sought for and agreed to by the learned council for the parties, leaves the case on. Did you after 2 weeks?
Lordship, I appear for respondent number 7. Can we get a date?
I have said also already.
27/11.
Obliged, obliged.
Lordship, there is an interim order, Lordship, that
The interim order, if any, should continue till the next list.
May it please lordship. Lordship, first I'm apologizing for not circulating a adjournment memo. May I mention item number 6 and item number 7? Item number 6, I'm respondent number 7, and item number 7, I'm the petitioners. We were supposed to file affidavits. I'm awaiting instructions. So Lordship, I'm praying for 2 more weeks. And I believe the petitioners in 6 has also filed another affidavit today.
Today will.
So Lordship, we'll file a consolidated reply.
Okay.
Morning, lordship.
Petitioner in 6,
Lordship,
they are
I've
going
taken,
to file
Affidavit.
an affidavit.
Yes, sir.
You are
Lordship.
Mr.
AI Kathar.
I've taken
Okay.
consent of the Advocate General and RM Das.
Okay, Mr. A.I. Kathar, learned counsel for the petitioners in item 6 and for the respond number 9, 10, and 11 in item 7, and Miss C. Goswami, learned counsel for the respond number 7 and the petitioner in 6. Respond number 7 in 6 and the petitioner in item number 7 are present. Full stop. Ms. Goswami has submitted that in item 6, you are going to file any affidavit?
Yes, Your Lordship.
Okay. An affidavit in opposition or what?
It will be Sir Rejoinder because they filed a rejoinder.
Okay, Surrender, S-U-R-R-E, huh? In item number 6, within 2 weeks' time. First of, Mr. Kathar has submitted that he is going to file an additional affidavit in item 6 during the course of the day. In that view of the matter, Ms. Goswami has also sought for 2 weeks' time to file a reply to such affidavit. First of, it is submitted that the prayer is made with the consent of the learned Advocate General, Assam, and the Standing Council, DHA Council. First of, as in view of the above prayers, list the cases on 25/11.
Good morning, my lordship. Lordship, item number 10, kindly allow me to adjournment for this. For today.
Item number
Item number 10.
10.
Yes, lordship.
You are for whom?
I'm appearing on behalf of M. Sanda.
Petitioner.
Yes,
What is the reason?
and personal difficulty and my senior is visa.
Okay. A prayer is made on behalf of Mr. M. Chandralan, counsel for the petitioner for adjournment by Mr.
M. Sanda.
Your name?
My name is D. Regan. I'm appearing on behalf of M. Sanda.
Your name?
D. Regan.
Learned counsel. First of it is submitted that consent has been taken from the learned counsel for the respondents to make the prayer. First of, release the case in the first week on a date in the first week of December.
Like, this is settlement of market mirror. It was fixed yesterday mirror, but not listed. So my prayer.
Settlement of market amarat nahi hai. Settlement of market is not bench by.
May it please your lordship, I beg for listing lordship, next week any date matter related to land acquisition lordship.
Already so many, give it to the court master.
Obliged lordship.
Lordship, I beg to mention for listing on admission matter. Notice what issued 27.
Subject matter.
Subject matter, my lord, petitioner's husband died due to COVID-19. So there was some scheme. Till date, despite of honorable.
Okay, give it to the court master.
Next week, my lord.
Give it to the court master.
May I please, man? So this is a motion matter, my lord. We have challenged the revenue board's order.
Next Monday.
Obliged, my lord.
Supplementary list for motion, item 13. Item number 13.
Yes, you are supposed to make submission. We'll wait.
Daily list for admission, item 1.
Yes, you have got instruction.
My lord, that they need some time, my lord.
No need, then we'll take up at 2. We'll dispose of.
My lord.
No need waiting.
My lord. Item number 2.
Hey, that one. Item number 14. 14. 1 minute. Pleading completes, my lord. 1 minute, yes, reading is complete.
Yes,
huh?
Lordship, please, hearing, the Lordship may fix the matter for hearing. Your Lordship.
Item 2.
Interim আছে নেকি?
এইটো কি হৈছে জানো চাব লাগিল ন? It was heard by Korean bench.
Yes, Lordship.
It reflects.
No, my lord, it needs, my lord, hearing. We have filed affidavit.
No,
and-
a Korean bench
No, my lord.
Heard the matter
No,
and
no,
some
it
length.
is not part of matter.
Yes, Lordship.
Some length.
Some length, yes, Lordship. Before court number 7, Your Lordship.
Hmm. So petitioner side addressed.
My lord,
Petitioner side addressed already.
no, my lord,
You took the adjournment.
no, they says, my lord, fixed for a hearing, my lord. I have no any objection to that.
No, if it is heard by some length by.
No, my lord, that was, my lord, they were asked me to obtain instruction, my lord. In the meantime, I have seen that the file, my lord, one affidavit has been filed by our colleague. So, pleading is completed.
No, I am saying
Yes, I know.
it is recorded in the order.
Maybe, my lord, this may be taken up by this bench or this bench, there is no bar at all, my lord.
No, if it is heard by.
No, my lord, this is a hard, my lord, they asked me to obtain instruction only.
Yes, Mr.
It is hard at some length, Your Lordship. That's it, Lordship.
If it is heard at some length, then why should we?
Yes.
You are there, Mr.
Do you know?
Gogoi? Was it heard at some length?
ৰবি তো শুধু এটা ইনষ্ট্ৰাকচন ল'বলৈ কৈছে
It's not hard.
মই কৈ আছো ask me to obtain instruction.
I don't know what transpired because it is there, address the court on behalf of the petitioner at some length. That is why.
No, I have any choice of my lord bench, my lord. Why he is saying like that, higher than angst? Lordship may taken up, other bench are taken
I
up.
go, Mr. Yeah, I have not said anything. I have said what.
No, there is no
In
hearing.
the order. That is.
Not hearing, my lord. নাই কৰা, নাই কৰা.
Okay, what do you want to do?
Hearing, fix for hearing, Your Lordship.
Fix for hearing, my lord.
When?
Any third week of December?
December? To take a look.
13 December is holiday.
14.
14th December. Sunday.
Only Sunday.
Lordship, 15.
15th Monday, but hearing day may be Suj, my lord. 16th Tuesday.
Is 16.
11?
Sir, 11, he won't be available, Lordship.
9th?
Lordship, till 11, he's not there, Lordship.
No, that will be, that week will be declared again motion days. That is why.
Sunday.
After vacation.
That may be better, my lord.
After vacation.
Because he is not a urgent matter, my lord, of the subsidy. 26. Oh, 26.
26.
Other hearing will लिखा नहीं होगा.
नहीं
Some length will लिखा order.
So 25.
आज की मैं regarding, no?
Mr. P.K. Bora,
Chalo.
learned counsel for the petitioner. Mr. T.C. Shutia, learned additional senior government advocate. On behalf of the respondent Industries Department Authorities. And Mr. K. Gugoi, learned Central Government Council for the Union of India. Are present first. The council for the parties have submitted that as the pleadings, exchange of pleading is complete, the matter be posted for admission hearing on a fixed date. Then 6th of January.
6th.
as sought for and agreed to by the learned counsel for the parties, raised the case on 6th of January 2026 in the admission column.
Supplementary list for admission, item number 14.
Direct purchase, my lord. We agreed, my lord, necessary formalities were done, my lord. And thereafter, they paid half the money. We surrendered possession of the land. They began construction and the road is almost complete now. Now, when it came to payment, my lord, now they've said that no, we cannot pay you as much as we had agreed upon because as per recent notifications, the zonal valuation of tea land has declined, my lord. That is the simple case, my lord. Now, it almost took a personal appearance for to make them file their affidavit by the DC and the circle officer, my lord. Thereafter, my lord, the matter was taken up for consideration on 13/6, my lord. We cited a judgment saying that this could perhaps cover the issue, my lord. At that juncture, the PWD said that we want to examine. Perhaps that judgment is under appeal, my lord. However, no information was furnished whether there has been any appeal or anything. My lord, thereafter, my lord, repeated prayers have been made. Now, the difficulty is, my lord, we've already surrendered possession of the land.
Yes.
Now, PWD did not bother to file the affidavit for so long. And last occasion, my lord, they said that though we have instructions, we want to place it on record. Lord, if it lingers this way, my lord.
Lordship, we will be filing it today, Lordship, the affidavit.
Okay, you are filing it today.
Lordship.
Then it is okay. Yeah, filing it today. Okay, we'll put it on next week. B.D. Reka, learned counsel for the petitioner, Mr. B. Goswami, learned additional advocate general, Assam, for the state respondents are present. First of Miss
H. Barua.
H. Borua. Learned counsel representing Mr. P. Nayak, learned standing counsel PWD has submitted that the affidavit on behalf of the respondent PWD authorities is going to be filed during the course of the day. Also, in view of the above submission, let the case be listed on 13/11. Sorry. 20.
Lord,
Okay,
can I
Mr. Pinayak.
Lordship.
endeavor to disposal if
Pinayak. 20/11/2025, first of, and endeavor to will be made to give consideration to the activities. On which day?
Item number 5.
Kindly pass over the matter for the time, my lord.
Item number 8 for us.
May it please your lordship, I have received instruction, my lord.
What is this?
The review has been filed, is yet to be numbered, my lord. They have filed one IA for condonation of delay.
Lordship, they are consist of 598 disputes, Lordship. So, Lordship, whatever here in this case, Lordship, the election for the form by committee, Lordship. So, here is
593 days.
So, I have in para number 4, Lordship. And the writ appeal was granted liberty fee filed. And then writ appeal number, Lordship.
What is this review petition?
So, whatever, Lordship.
What is the order?
So, Lordship,
For which you are seeking review?
Lordship, page 16 can define, Lordship.
Page?
So, in the page 16, Lordship, annexure 1.
No, in the main petition.
Yes,
Or review petition.
In my review petition, Lordship. Yes.
Lordship is page 19, my lord.
Page?
Page 19, relevant portion is 20.
No.
Page 19, last para, my lord.
19.
Lordship.
Let me read. For the petition. Same petitioners.
Lordship.
The review petitioners are the petitioners there.
Yes, Lordship. Lordship, back. Revenge is your lordship, sir.
Let me read.
Yes. Yes.
Yes, what review you are seeking?
Lordship, whatever lordship.
Of this order?
Yes, lordship. So concern is, lordship, in the year of 2018, lordship. So the one notification was issued for conducting the election, lordship.
Huh?
Conducting for the election, the general meeting, AGM, lordship. So kindly find, lordship, page number 46, lordship.
No, we'll not come to that. We are into the order for which you are seeking review. Page 19, that is order dated 4/10/2023.
Yes, lordship.
Yes.
Yes.
What is the wrong there?
Lordship, my grievance is here, lordship.
No, grievance is not. Review jurisdiction is limited. No grievance.
So let
You confine yourself to the order
yes,
sought to be reviewed.
so kindly appreciate, lordship. So
No, will not appreciate. The order is there any allegation against the counsel for the petitioner? Huh?
so lordship, what?
Is there any allegation against the counsel for the petitioner?
No, no, no.
No. Then it is a consent order.
So
Come to page 20 of the review petition. Second paragraph.
second paragraph.
Read. Mr. So-and-so has also
Agree.
agreed. If it is a consent order,
Lordship, page 19 or 20, lordship. Page 20. Second paragraph.
Second paragraph, Mr. So-and-so has
Has also agreed to the said order, but he sought refund of the
refund allowed.
fee earlier paid by his clients. In view of the statement they made in the para number 10, the counter affidavit filed by the respondent number 6, it is clear that the respondent are willing to refund the nomination fee to the petitioners. But the department has not been refunded any kind of the fee, nomination fee. And concern is
For that contempt. If remand is not done, for that contempt, not review. If refund is not made,
yes,
for that contempt, right? And it is a consent order. Is it not?
but not clear the 4 weeks for the date of suspension, sir.
And if they did not notify within 4 weeks, then also contempt.
Yes, Lord.
If refund is not made of the nomination fees, then it is contempt. Right?
Right, Lord.
And if the AGM and election is not held within 4 weeks, then it is contempt. Where from this review
So Lordship, so one thing is, Lordship, so I may allow to, some time, Lordship, that if there are two.
No time,
Lordship, by tomorrow, Lordship.
no time, no time.
So concerning, sir, Lordship.
Consent order, you are seeking review, you had gone to division bench.
Yes.
Somehow you escaped from the division bench by seeking liberty.
Yes,
Then thereafter you sat for 2 years. Then application is filed for review, seeking condonation of delay of
590.
500 so and so days.
Lordship, just for-
Against the consent order, where is that
Lordship,
power of
just-
review?
Just for a moment, Lordship, so I may allow to,
Already notice has been, Janoni has been issued.
Yes, my lord.
End of the matter. Your grievance is redressed without filing any contempt petition. You participate. Satisfy yourself. with
Lordship,
this.
kindly find Lordship the
No,
page.
Mr. Das, satisfy yourself.
23
Your
days.
grievance has been mitigated. No more cause of action.
So I'll receive that particular notice.
No, next page, next page.
Oh, yes, Lordship, the election will be held on the 13th, Lordship. I have received, Lordship. I have filed one IA also, Lordship.
For what? Before listing, that is to be dismissed.
So IA has not been registered, Lordship. So my prayer, Lordship, in the year 2018, Lordship, the election has not been held, Lordship.
That
So
is
now
gone.
the
All these are gone now.
Lordship, the pendency of the review petition, Lordship. So they have, how it possible, they have to file another notice, Lordship, for the
What?
newly election. held.
Review is not born,
Yet to be numbered.
yet to be numbered. Your baby is not yet born.
Lordship, kindly fix by tomorrow, Lordship. I'll take some instruction from my client, Lordship. Kindly fix tomorrow, Lordship.
You all take instruction also, how much cost they will pay.
Lordship, kindly fix that.
Cost.
We do respect, Lordship. But
Cost.
kindly fix by tomorrow, Lordship. We do respect, Lordship.
Tomorrow, this court will not have time to dismiss it with cost. Day after tomorrow.
Chapter, yes, Lord. Yes, Lordship.
Because cost is to be imposed there.
Chapter tomorrow, Lordship.
On the prayer of Mr. R.C. Das, learned counsel part of applicant. That's review petition, lays the case day after tomorrow. And instructions placed by Ms. M.D. Bora, learned standing counsel, Corporation Department, are kept with the case record.
Lordship, if possible, Lordship, the first item, Lordship, because on that day, Lordship, the election will be held, Lordship. Nomination paper will be submitted, Lordship.
And then tomorrow.
Yes.
Then tomorrow, first.
Yes, Lordship.
Lordship.
Must have.
Otherwise, they will
Yes.
say
Lordship.
that no, election is High Court case.
Yes. That's happening, Lordship, because they are filing IS and said we are filing
That
IS
last-
for Honorable
yes.
High Court. They are not going to hold any elections. It's
Must
happening.
have.
Deeply obliged, my lord.
And tomorrow, you get the order placed before the concerned
Lordship.
official.
My lord.
Must have.
I'm so deeply obliged.
Supplementary list, item 15 for orders.
Nifty, Lordship. Lordship, I'm being led by Mr. K. N. Chaudhary. He's on legs in court number 1. Matter may be passed over for the timing, my lord. Obliged.
For motion, supplementary list, item 13.
Challenging in my lord, Board of Revenue order.
No, Board of Revenue, okay, challenging, it is a challenging order, but what is the basis?
Nothing,
Foundation?
my lord,
Foundation is zero.
0. Page 19, para 8.
Foundation is zero. Why should we keep one repetition on the board? That day I asked Mr. Sharma to address on the point on merit against the Board of Revenue order. He claims his right on the basis of an unregistered
Sell it, my lord.
sale deed. No right flows from it. We'll wait for some time.
Can it be on my lord?
We'll wait, thereafter we'll fix.
Item number 14 for admission.
Yes, Mr. Shah, what to do?
Yes, my lord,
The victim could not be recovered, Your Honor.
We have seen the report.
Yes, Lordship, the petitioners went to the police station to initiate.
May I please, Your Lordship, my lord? This matter, my lord, earlier heard by your lordship, my lord, on earlier occasion, an order, certain order has been on 6/2.
No idea, no idea.
No, I remember your lord, repeat that lordship. The only thing, my lord, the matter, my lord, regarding, my lord, establishment of brick field, my lord, and 2 ground, my lord, 3 ground, I have selected, my lord, because the Supreme Court order is there, that say, but till now, my lord, eco-centricity is not notified. In that case, my lord, 10-kilometer radius should be declared as a eco-sensitive zone. But here in this case, my lord, the brick lane is situated within that, my lord, 10 kilometers, within, my lord, the eco-sensitive zone area. And second branch of my submission before your lordship is this, my lord. There is a, my lord, there is an order of this court division bench, order is here, my lord. That order said, my lord, if the brick lane is, my lord, established, my lord, whether it will affect the surrounding land. We are the petitioner having the agricultural land around the.
Okay, just a minute then, just a minute.
Tell this, your lordship.
Just a minute. Yes, what happened after that initial order? The board took over. Yes. What is the stand of the agriculture department?
They have filed a well, affidavit wherein they have earlier they have filed two affidavit, my two my lord,
Is respondent number
five my lord,
5?
five my lord. Earlier my lord was there was 8 round litigation. Earlier my lord, each application was filed. There's a report by the agriculture department which stated my lord, you will briefly allowed to be my lord function will affect my adjacent land.
Let
Subsequently, but
let me go through this phase one.
That was one file in 2012 and 13, my lord.
Let us, let me go through the fresh one.
Well,
Let me go through the fresh one.
yes, only my lord, the phrase one, they kindly see, my lord. They certain, my lord, is not suitable for major cultivation. Kindly see. Major cultivation. Who does it? They have not stated anything I want to affect, my lord. Nothing to affect. Paragraph 4 and 5, my lord.
Okay, and according to the agriculture department, land is not fit for major agricultural practice. Now, what about this land? There are, what is the stand of the forest department?
My lordship, my lord, I leave an earlier order is 6/2/2025. And whether lordship asked them to file affidavit, whether it will within that my lord eco-sensitive zone, and whether this brick land is within the my lord that midst of the Rajamine and Buramine. But they have filed only my lord affidavit stating that my lord, this brick land is within 10 km radius, so it is within the my lord default eco-sensitive zone. Because as per the Supreme Court order, kindly see there my lord affidavit.
1 minute.
Lordship, kindly see the order dated 6/2/2005, paragraph 9, your lordship. That order 9, paragraph 9, 10, and 11. Everything will reveal on that after going to that order, my lord. Agriculture department, my lord, page, my lord. Page 194, my lord. Page 194, my lord. Page 194. Sub paragraph 4, my lord. Affidavit filed by the affidavit, my lord.
This is a report or what?
Oh, that is the my lord.
This is the 444.
Yes,
Okay,
sir.
444. So Vitora. So, what is the decision before the NGT?
NGT, my lord, there is a case is pending, my lord, but there, my lord.
Who is the petitioner there?
Here, my lord,
Before the NGT?
one, my lord, impulse here, my lord.
Whether there has been any finalities?
No, that has not finally not been disposed of. Their committee has been formed, my lord. Their committee consists of, my lord, member from the Pollution Control Board, Agriculture Department, Forest, and that committee has stated, my lord, this brickling is within, my lord, 892 meters from the.
No, that has been corrected, 1200 meters now.
No, my lord. Well, they have stated, but NGT has not been corrected. It is corrected by the Forest Department. The committee has been not been, my lord, corrected. But anyhow, my lord, even 890.
It is 1200 meters.
Within the midst of that, my lord, Ragamayang and that.
Now, whether this is within that interspace,
Yes, ma'am.
within that interspace,
Interspace.
yes or no?
Yes, yes.
That is your claim.
Yes, my lord.
But nobody has said,
But they have, my lord, only thing will clarify that point, my lord.
oh, no, your forest.
No, no.
Oh,
I'm for the agriculture.
yes. Because I don't know for what reason I recorded it, but I recorded in the order that for the PCCF to clarify whether the interspace of 3 kilometers between Rajamayong Hill RF and Pobitor RF is also included in the eco-sensitive zone proposed in the order.
Yes, Lordship.
Has that issue been answered?
That issue has not been answered, Your Lordship, because right now that's noted that Pobitora, this eco-sensitive zone, that has not been yet notified. So determine whether the interspace area falls within the eco-sensitive zone, it cannot be determined at this point of time. Because as per our report, that's
In a proposed.
It's a proposal.
No, in your proposed, it is not finalized.
It's not finalized.
That is a different issue. Finalization is sub judice before the Supreme Court.
Yes.
But so far as your proposed eco-sensitive zone, whether that interspace has been included or not.
So that has to be included, Your Lordship, because in default, if there's not notified, only proposed, it's held at 10 kilometers. 10 kilometers.
Your proposed eco-sensitive zone is 10 kilometers.
10 kilometers. If it's not notified, because the proposal has been sent in way back 2012. It's 5,25.
Why such a difference?
Lordship.
That any national park or wildlife sanctuary must have an eco-sensitive zone of minimum 1 kilometer.
1 kilometer. Minimum 1 kilometer.
Minimum 1. Then in the wherever it is proposed, proposal has not been given. 10 kilometer buffer zone as ESG as indicated in the order. Shall be implemented. What is this Ian
Godavaram. This is pending
Tirumul
for-
pad.
on 6/5/2025.
That order,
That order is there, Lordship.
minimum 1 kilometer in para 56.1 and minimum buffer zone of 10 kilometer in 56.8 and shall be implemented. What is the problem?
Problem is, my lord, if weekly needs, my lord, functioning, my lord, our adjustment will be damaged, my lord. That is the.
And what is the stand of the forest department in the affidavit?
They simply said, my lord, that within that 10 kilometers, as per your lordship order, my lord, that 6 to order, that stated, my lord, to file if it in the eco-sensitive tool and where.
Dear respondent number?
Forest is respondent number, Your Lordship.
294.
Six, seven. 6 and 7.
6 and 7, Your Lordship.
What is the stand? 1 minute.
1, 6 and 7.
Okay, 1 minute. Now this demarcation of the boundary is complete.
This demarcation of boundaries, no, not yet complete. Not yet complete. Like Povitra, this is Povitra area. This demarcation is not yet complete. This is reflected in page 158 of this order of this Honorable Court, Your Lordship.
158.
158. If I may read, Your Lordship. 158. At para 5, Your Lordship. A perusal of the above quoted order would show that proposal for 21 national parks and wildlife sanctuaries were yet to be received by the Ministry of Environment Forests, which amongst other include the Povitra Wildlife Sanctuary. The Supreme Court categorically directed in the said order that an area of 10 kilometers around 21 national parks and wildlife sanctuary included the Povitra be declared as eco-sanctuary zone by the Ministry of Environment Forests. The said declaration was to be made by the Ministry of Environment Forests at the earliest. Therefore, from the said order dated 11/12/2018, the Supreme Court did not declare any area of 10 kilometers around Povitra Wildlife Sanctuary eco-sanctuary zone. Rather, direction was issued to the Ministry of Environment and Forests to make the declaration the earliest. On the other hand, if this court takes into account the impugn order dated so-and-so, Deputy Commissioner Morigao has revoked the NOC dated so-and-so on an assumption that the land wherein the petitioner Bricklane Industry was located is in the eco-sensitive zone of Povitra Wildlife Sanctuary. This aspect is in the opinion of this court was based upon an incorrect reading of the order passed by the Supreme Court on 11/12/2018 in the case of T.N. Godavaram. Be it as it may, when the matter was decided to so-and-so, this court inquired as to whether the Ministry of Environment and Forests Government of India has complied with direction passed Supreme Court dated 11/12/2018 in T.N. Godavaram case. However, as the state query remained answered, this court fixed the matter to further consideration. When the matter was taken up by today, the Learning Standing Council for Forest and Environment placed an instruction issued by DFO, Guwahati Wildlife Division. The same instruction is kept in record and so-and-so. From the perusal of the same instruction, it reveals that no draft proposal for notifying eco-sensitive zone of Povitra Wildlife Sanctuary has been sent to the central government from the Office of PCCF and Head of Forest Force, Assam. That's further mentioned that out of total notified area Povitra Wildlife Sanctuary of 38.81 square kilometers, 10.98 square kilometer of Haasland has not been handed over to Forest Department. The boundary of Povitra Wildlife Sanctuary, as per the government notification 17/3/1998, had not been demarcated till date. To the said communication, there are various enclosures. Amongst the various enclosures, it reveals there is a communication issued by the additional PCCF to the government of Assam, who, white communication editor so and so, informed the Ministry of Environment, Forest, Climate Change, Government of India, had not issued any notification, declared eco-sensitive zone of Pavitra Wildlife Sanctuary in terms of order 11/12/2018, passed by Supreme Court in so and so. Today, when the matter was taken up by the Union of India, represented by the Secretary of Minister Environment Forest Department, was represented by Mr. R. So and so, the learned of India, who had, upon specific query being made, also apprised this court till date, no different notification has been issued by the Ministry of Environment Forest, New Delhi, as per direction headed so and so, passed by the Supreme Court, judgment of T.N. Godavaram, Your Lordship.
Now, this order, June 3, 2022, in T.N. Godavaram, that was taken note of.
T.N. Godavaram taken note of, Your Lordship. Taken note of.
Taken note of.
This, the order is taken note of.
Because this judgment is on 30, 2023. There is a judgment June 3, 2022. 2022 10 SSC 544. Is that direction taken note of? In the judgment?
That?
June 3, 2022. That is no boundary, whatever. No boundary was.
Do not do, there is a letter order of what, which is taken note of in the judgment at page 161. 2023 FT online 504. In the same case, a letter order in the same 26/4/2023.
What is that order?
Notice that order, one of my affidavits I have annexed.
On the Department of Forest. For it to bring to a notice of any further development. What is that order?
This
I think first we need a compilation of this order. T.N. Godavaram. Otherwise, very difficult to go here and there and.
True.
Which part? 1 minute, 1 minute. Hey. This is order dated?
26/4/2020.
Where it is mentioned.
There are other more orders in 2004.
1 minute, one by one. Don't pile up orders on me.
Page 292.
Oh, itu order lagi.
Trust me, allow me to submit one clarification, my lord. Page 292, my lord, paragraph 65 and 66.
No, I am reading this order
Yes, sir, that order I'm referring to, lordship, my lord.
because
That order.
in my previous order, this order was quoted that of 56.8, 10-kilometer buffer zone. Is 6.
Right, sir. 6, 4, 56, 6, 2, 45, 56, 56.8. It only figure on we say paragraph 56.4 and 56.5. That's it. We don't know any.
What is those 21 national parks? Obituary is one of them.
There are 28 of each order.
Huh?
There are 28 of this order.
Which order?
26 for that project. Page number 270.
And that I have seen, 276,
There are
para 27.
27. Yes.
No, what are those 21? National parks? Somewhere I have seen.
Okay, yes, sir. It is in the order document in at page 150.
156, your lordship.
150.
156, the list is there, down below.
And what is that order? 256
150.
or 262.
Some Puvito century.
I'll come to 277. Mr. Gogoi.
Lordship. 277 affidavit. Affidavit copy.
That judgment of judgment.
Thank you. 270 Goa Foundation. Lordship.
Huh?
Follow question.
That judgment 26 for 2023 order
Hmm.
in Godabaram.
Yes.
Internal page maybe. The court then recorded 21 national parks and wildlife sanctuaries in respect of which
Have not been received.
proposals have not been received by the MUFs and CC alongside its anguish that though 12 years had been passed, no effective steps have been taken by the state governments in respect of national parks and wildlife sanctuaries named in the order. Therefore, the court directed that an area of 10 kilometers around these 21 national parks and so be declared as ESG by the MEOF CC. Liberty was granted to the state government to move an application for modification of the state order. So this direction was to that Ministry of Environment.
Yes.
And that was not done, you said.
Not done. Since this 21 national parks, this 10 kilometer will apply.
Huh?
This 10 kilometer, this as stated in that 10 kilometer around this 21 national park violation shall be declared eco-sensitive zones.
To be by the Ministry
of Environmental Forest and Climate Change.
That was not done.
It is not done yet. That is.
Where it is said that it is Ministry of in the judgment? That it is mentioned as 11 December 2018 order, right?
Mm.
Where is it 11 December 2018 order?
Page 1.
156. 156.
156.
And this is underline.
Yes.
Right. But this judgment of June 3, 2022, Godavarnam, which I quoted in the order, that was of 2018.
Yes.
Direction was Ministry of so and so.
Yes.
Will declare.
Yes.
That was taken note of in the judgment. Now, in June 3, 2022, Godavarnam, para 56. Right. Para 56. I quoted one and second is 56.8. Right. 56.8 in my order. See?
Yes. Page 257.
257. 257.
Yes. Para 56.
Huh.
56.8.
There is no mention of Ministry of Environment now. That is done away with. After 4 years,
Yes.
Supreme Court did not refer the matter to Ministry. They issued a direction under Article perhaps 142.
Yes.
Now,
Now it's one.
now Come to 262. Running page. Next order, April 26, 2023.
Yeah, that's not the amount.
All this Ministry of Environment was of 2018 order. Right? In the judgment that is recorded. But there is subtle change. You implement 10-kilometer buffer zone.
Buffers.
In 2022 order. Right? Now come to page, the next order, April 26, 2023. Just come. Now, Mr. Gogoi, you have.
Lordship, I have the copy.
Now, first to para. The present I is filed by the Union of India praying for modification, clarification of the order dated 3rd June 2022. Right. Now, second para. The applicant specifically seeks modification of the direction contained in paragraph 56.1 and 56.5, not 56.8. Right. I have not read the entire order. Was there anything that seeking modification of 56.8?
No.
No. Okay. So this or direction was without any reference to Ministry of Environment and Forest. It is clear that in respect of sanctuaries or national parks for which proposal of a state or union territory has not been given, the 10-kilometer buffer zone as eco-sensitive zone, right, shall be implemented. Within that area, the entire set of restrictions concerning an ESG shall operate till a final decision in that regard is arrived at. Now, what is the consequence of this direction? Because this particular, though this judgment was rendered subsequently in a petition prepared by respondent number 12 as the petitioner, maybe a mention was made, but it specifically took note of that the observation in 2018 order that Ministry of so-and-so should declare, and Ministry of so-and-so did not declare. So it has not come into effect. This is our view. In the judgment,
yes,
in respondent number 12 street petition, right? Then this came. This is the final direction. Then thereafter, application for modification by the Union of India. I have not seen the entire thing. You have to go through it. And it's sought clarification on two particular subparagraphs, not 56.8. And that is Union of India. If that is so, then this is in operation.
No.
If this is in operation, just you will clarify. Then 10 kilometer will within 10 kilometer embrace. It will embrace the brick clean in question. Right.
Yes.
Now you have to say.
What happened?
Just clarify.
If that has attained the finality and if point is not changed.
I have not read the entire order. It is a long order. But first two paragraphs says, Union of India did not seek clarification on 56.8.
Yes.
It sought clarification on 56.1 and 56.5, seeking some dilution. You go through it. Is there any dilution or modification of the direction in 56.8? They are saying you are not finalizing the boundary. Whatever be the stage, within 10 kilometer, your thing is going to come.
May I just point out?
Yes.
The order para 150, page 151 takes note of the order
151.
151 of the coordinate page.
Yes.
takes note of the order of 2018 because of.
But whether it takes note of 2022.
Yeah,
That is what I am asking.
Yes, because.
It took note of 26 for 2023 also.
Yes.
But in between, there is the
Third June.
order. We accordingly direct. The paragraph 56 starts with 3 words. We accordingly direct. And direction is under article perhaps 1. Right. Now, that judgment will be per incuriam. Binding precedent of a Supreme Court is overlooked or not placed before the court.
It was, it was placed.
That is why I have asked. I have not read this big one.
Because if someone takes note of 2023 judgment, then at the first paragraph itself that.
No, everybody reads the operative part. The problem lies there.
Page 149, because case number 149 order was challenged. Therefore, this order came. Because immediately our listing was closed for the 2018.
Whatever, June 2022 order has been discussed or not discussed. This is my first and foremost query. And more particularly 56.8. You answer. I have not gone through the entire thing. You are the person dealing with the case day in and day out. Tell me. Yes, Mr. Borua.
That will not be, my lord.
No, don't say without reading. Otherwise, my observation will be par incuriam.
Only that, my lord.
You tell me this judgment, the impugn order, then all this has diluted the position in 56.8. Yes, Mr. Gogo, you can also highlight. I don't want to read the entire line by line.
Even I have read, my lord, that clause has not been interfered. It stands there.
I have not read the.
Lordship will give me some time, I can pinpoint there. I have to
Because this is the issue.
Yes, yes.
And if that is not touched in the earlier judgment, it might be par incuriam. Because that is a direction we hereby direct. And that is then, in that case, it will be in ignorance of a binding direction of the Supreme Court. And then in case it would amount to par incuriam. Right? And that is, it is for you to submit. This is what has come to my notice. And whatever is the position, within 10 kilometers, your thing will be embraced. It will come within the
10-kilometer buffer.
radius of 10 kilometers by anyhow. You cannot escape that.
Only thing is that 56.8 will only be applicable to centuries where proposals has not been sent. But
We have
in my
not sent
case-
any proposal.
Sorry,
Not sent any.
No, page 51 is the one.
No, it's not
Page
final
51.
proposal. That was
Page
scrapped,
51
my
is
lord.
the proposal.
That proposal is scrapped, not
Different
scrapped.
thing, but it was
So-
sent.
It is scrapped.
Scrapped.
It didn't see final, it was scrapped, my lords.
But it-
Because now what has happened, my lord, after new development is there, government, there were some issues with the revenue lens. When proprietor was notified, some government khas lands were not given. So government wanted to again have a proper demarcation. So that was done. When that was done, a new IA was filed by one gentleman named Rohit Chaudhary. Now Supreme Court has set status quo and everything. Status quo, my lord. No more tinkering with the boundary. That is also another aspect, my lords. Because that also admittedly clears, yes. It also clears that there is today, as of today, my lords, there is no proposal written sent, my lords. That Supreme Court stands that 10 kilometers has to be maintained. If my learned friend hands me that compilation, my lord, I'll pinpoint where it is, my lord, that it has been discussed and not touched.
Because this is the point whether this stands.
Yes.
Is this 56.8 stands as on date. Then 10 kilometers by whatever way, you cannot escape out of 10 kilometers. And according to Mr. Borua, it is the interspace between the two, one reserve forest on one side, the other, Pobitora on the other side, 3-kilometer interspace. And within that interspace, his brick lane is located. Though from Pobitora, it is 1200 meter. Similarly, I think it will be 1800 meter from the other reserve forest. In that way, he can escape. But if 10-kilometer comes,
He goes.
he goes. This is my prima facie view, subject to correction from your side. I have not read the entire thing. And the other judgment did not refer to this particular point. Right?
Well, I was the counsel there. I tried to pinpoint, somehow it was not reflected there. It was
Because
there also.
original 2018 direction was that Ministry of Environment should declare. But this Supreme Court expressed some dissatisfaction, then made this order. Nothing has been done by the state governments, so and so, we hereby direct.
10 kilometers.
So 10 kilometers stands. If that stands, and if it is clear, as Mr. Gogoi has said, if it is correct that in respect of sanctuaries or national parks for which the proposal of a state or union territory has not been given, the 10-kilometer buffer zone as ESG shall be implemented. Within that area, the entire set of restrictions concerning an ESG shall operate till a final decision in that regard is arrived at. And final decision in TN Godavaram, that is continuing for last 25 years.
Yes, ma'am.
So, I have placed you whatever I have found prima facie. So, this perhaps is you go through and the entire judgment, tell me in the subsequent judgment, whatever, maybe. So, I am ready to accept whether this direction has been diluted. And if Mr. Gogoi's statement is correct, that no proposal is sent,
No, nothing.
then this will apply on all force. Right? Then restrictions in the ESG might be that there is prohibition for a brick kiln. Maybe, I don't know.
Page 51, I don't know that. Because it's a proposal at page 51. It's sent back to the government again.
No, it never saw the light of the day. Okay. It is just an internal communication, and now because.
It was sent to the ministry.
No, send is something.
Address.
But it was never placed before the.
Will not observe anything, we'll put it day after tomorrow.
Yes.
Just check the judgments, TN Godavar. Thereafter, we'll proceed for hearing. Right? If it is dilute, I'll not give the final consideration day after tomorrow. We'll just say 56.8 stands or does not stand. If it stands, then you think of your subject.
I don't have this copy either. Otherwise, I know
Which
the
one?
judgment by heart. Because it pertains to a sanctuary called Jammu Wildlife Sanctuary, where it was reduced to 1 kilometer. I know it by heart, but since I don't have the copy, day after tomorrow I can show it.
Just highlight the things which are, because otherwise reading the whole thing, one will get confused.
Vertigo. Reading the Godavaram, my lord, there's two sets of.
7th round now from 2011 permission. For the first time, we opened it in 2020.
Mr. Bora will not at 8 also.
Bora is constructing, my lords, house. It will go on then.
We have the latest technology. We are not creating any pollution.
Zigzag.
We have.
But the location is the problem. We'll have it more, because today will be also rising.
Yes.
Mr. Borua, you go through all the TN Godavaram.
Yes, sir.
Whether this 3rd June 2022 judgment and specifically 56.8
Has been diluted.
diluted subsequent, because there are many other judgments in TN Godavaram itself.
Yes, ma'am.
So
Just
just check.
occupies, my lords, 2 sets of SCC only. Two sets of 2000.
So find out whether it has been diluted or not diluted. If it is not diluted, and if the stand of the forest is that no proposal,
No.
then it will apply on all fours.
Another question is there. If there is a violation of a order of a Korean Godavaram case, where the petitioner should approach, there are judgments to that also. It has to, if there is a violation of that, there is a committee constituted under Environmental Protection Act, it should approach the committee. or the-
It is for you to approach.
But if
Yes, madam.
the petitioner is alleging violation of the Supreme Court's order. Therefore, if there is a violation, the remedy is to go to the apex court or the CEC. That is a
No,
separate
150
court. 140.
6.8, I think Article 140.
141.
One will apply.
Yes, madam.
Okay, well, you have to think it over.
Bora is disclosing all his defense, madam.
Okay, R. Borua, petitioners.
7 lakh accepting.
R. Gogoi, Environment Forest Department, Standing Council, 1, 2. H. Sharma.
3 and 4.
Additional Senior Government Advocate Assam, for the response number 3 and 4. P. Chaudhary. Another Standing Council, Agriculture Officer, Agriculture Department, for the response number 5. R. Gogoi, 2, 3. Sorry, 1, 2. 6 also, 7 also. S. Borua, Standing Council. PCBA, 8, 9, 10. Recorded. Union, anybody? No. And Mr. BP Bora, for the response number 12 per present. Post as sought for my reliant counsel for the parties, release the case on Thursday. Just point out this has been diluted or not diluted, then we will proceed further. And whether the judgment of the coordinate bench, this part has been taken note of. If that part has been taken note of, then there will be a difficult proposition again. Right?
Hardin part also.
No, there I'm there lots.
Only thing, my lord, that on that day, my lord, if I not reached in time, my lord, find the password time thing because of traffic jam, my lord. Sorry, sir.
I'll write for just 5 minutes. Subject to correction, yes. Anybody from the petitioner side? Where is Mr. Botagood? Morning they were there. You were not there.
Legs,
Botagood.
Yes, he was here earlier in the morning.
Right. I saw his presence. Let it be on Tuesday or Thursday? Okay, this is the case on next Tuesday. You filed objection?
We have filed.
You have filed?
Yes.
Okay. Mr. S. P. Talukder, Standing Council, Corporation Department for the opposite party 2 to 4, and Mr.
P. Khatonia.
PK?
P. Khatonia.
Khatonia for the opposite party 5 to 20 are present. Mr. Khatonia has submitted that on objection to the application has already been filed and the same is on record. Mr. Talukder has sought some time to obtain further instructions in the matter. Absolutely, please the case for you. Any interim observation?
Interim order is there, my lord.
Interim order, past order shall continue Finland.
For hearing, item number 9.
But petitioner, my lord, the owner of the previous plot.
Yes.
What happened, my lord, in 1870, from land has been made circular without any. So we filed an application. You had STO.
Now, what is the case about? Please tell me.
Well,
Yes, my lord, they have issued a letter, my lord, that
Petitioner is T company. Okay.
they will take over some land, that is
Who?
government land.
Who?
Government, my lord, that is issued by the circle officer. They
Where?
say that they will take over the land.
Which part?
My lord, at page 28.
Page 28. This is circle officer.
Yes.
Gopal Krishna Tea Estate.
Yes. Here, my lord, what
As to
happened?
the subject of, I'd like to inform you that the following schedule of government land under Kuthari Bagisa Kisam will be demarcated on so and so. As the below mentioned schedule of government land is adjacent to your land, so you are requested to present. Now it needs to mention the entrance of this area will be cleared on so and so. So this is a notice for demarcation and
Yes.
demarcation.
Marcation and partially there, my lord, encroachment will be cleared, they say.
Huh.
So naturally, my lord, they will take over the land. Now, out of this, my lord, only one dag is government land. First 190, 180. Yes.
Hmm.
Except, my lord, that all are, my lord, petitioner's land, patna land.
Okay, where from you're saying?
I'm saying, my lord, page, your lordship may come to page, annexure 1, page 16A.
Page
16A.
16A. 16A.
My lord, we have filed an objection, my lord, on coming to know that some land has been made circle, my lord, in 1970. So on coming to know immediately,
Originally, I am the owner of grants.
last survey, it was found that so and so net research are missing and only 170 are found in my possession. Now, on scrutiny, only so and so has been registered in our favor. Some darks of new list grant number so and so comprising 93 biga so and so has been known sorkari by mistake in your office. That 93 biga 2 katha 3 litres are already under our plantation.
This is your letter.
This is my letter now. Now, here, my lord, if you will also see in the letter.
Where is the Sarkari?
Now page 18, my lord, this letter, my lord, we have type copy. The original copy is page 17. At page 18, note is there, my lord.
Page 18.
Page 18, note is there. My lord, the protocol so and so and sub deputy collector so and so take so and so this settlement of হুকুম মতে 102-36 নিউজলি গ্রান্টৰ 123 তাকত 86 বিঘা মাটি সরকারি করা হয়।
93 বিঘা 2 কাঠা 3 লেচা সরকারি করা হয়।
This is my lord, why you done it, my lord, nothing is there.
1 minute.
Now,
One minute. This 168, 161, 158 to 64. So that page 28.
Yes.
These dark numbers, except 187.
Yes. All are, my lord.
All are Sorkari kora hoy. By this order.
By this order.
This is an order of
1970.
70.
Yes.
That order is available somewhere.
I don't have, my lord. They
Huh?
might have wrote, I know.
No, it is there.
Yes.
What is this order? Page 19.
Page 19. Yes. Well, this is a.
Let us.
Yes. 19, my lord, that type copy is page 18A. My lord, the deputy commissioner sent a letter to the commissioner.
Let us have the contents.
Yes.
The
Japan's
subject.
subject, I wanted to bring that allotment of settlement 93 biga so Gopal Krishna Tea Estate for favor of your so and so. The settlement, they say that for you settlement of Nogao has declared an area of so and so land as Sarkari from Kuthari another grant during last settlement also. The details of the declared Sarkari by settlement of Nogao so and so is posed. Now, the total area held by the garden, another grant so and so prior to resettlement was 179 biga 2 katha 8 lecha. Only 86 biga land so and so is left with the garden.
The land has been declared Sarkari by the settlement officer. Nagaon is still under possession of tea garden and under cultivation. The land ceiling case, Assam so and so, relating to the Gopal Krishna Tea Estate has been examined. It has been seen from the record under so and so. The garden authorities lands exempted under section 4(2) of the said act as ancillary to the tea cultivation has already been kept by the garden. It was found that total area under tea cultivation of the garden was at the relevant time is 22 biga 4 katha 8 lacha and land admissible under 5A of the already given to the garden. It is therefore certain that land measuring so and so is only purely Sarkari and the tea garden encroaching upon the Sarkari land. The said land already under possession of the tea estate, management of the garden authority has been paying for the allotment settlement of the said so and so. The garden authority has been paying TV revenue regularly. On the other hand, ejection of the garden from the possession of the uprooting plants will not serve any purpose. The land in question surrounded by so and so. Under above circumstances, the priority garden authorities for settlement of so and so. This is now government has written about that letter is important at page 21. With reference to above, I am directed to say that it seems that to a case of restoration of 93 biga 2 katha 4 lacha of land which Gopal Krishna purchased in 1960 and has been in continuous possession and under actually T. The circumstances under which the area was made Sarkari are not adequately explained in your request. However, the garden authorities may kindly be directed to produce the purchase documents, if any, in respect of garden land in question, and then you may resubmit the same to government for further inquiry for consideration of the law. So they wanted to know how it is made Sarkari.
No, where is your purchase document?
Yes, purchase document, and last time I had produced, my lord. Yes, I had. Yeah. This is the purchase document, my lord. No? That's it.
That will be a thing,
Where it is mentioned?
That page 14.
Page. Mine. That was mine.
That is our yes. Page 14.
Yes, I believe there are notices. Probably. Yeah.
And Jamabandi is also close, my lord. I have closed it. That's all. My lord, at page 54, my lord, I have enclosed the Jamawali. Of my affidavit.
No, card number, sunshine, problem. Rather, we see. Let me check. He's already under plantation.
Page 54.
Page 54. Two copies of the report of the stand. This is in 1978. 78.
What's it? It was it now. And now come to whatever, you have purchased the land.
Yes.
Just sequence of events. In 1968.
66.
66. Okay, 66. Then in 1970, they enforced Ceiling Surplus Act.
No, ceiling surplus, Lord, I have surrendered the land. This land was.
Come to 18.
Yes.
B.
Yes.
This observation.
Yes. Yes.
Para 2.
Yes.
Land ceiling case.
Yes.
Assam fixation of land on ceiling on land holding 1956 relating to Gopal Krishna Tea Estate has been examined. It is seen from the return. Garnet notice that land exempted under so and so has already been kept by the garden.
Yes.
Next where? It is therefore certain that land measuring 93 bigha, 2 katha, 8 lesa is purely Sarkari land.
Yes.
And tea garden is encroaching upon Sarkari land. That is his view.
Yes.
But the land has already been under possession of tea estate and the management have been praying for allotment of said land to him. Then has been paying TB. Injection will not serve purpose. So you then after it has gone in ceiling.
No, but this land has not gone to ceiling. Because this land, my lord, that land ceiling was 75, my lord. This was met Sarkari in 97. Because the garden, my lord, lands were after amendment only, my lord. We have kept it.
1970 Hukum Mote.
Yes.
By that it has been made Sarkari.
That by that has been solved by that. And that is mentioned in the Jamabandi also.
By that order, it has been made Sarkari. This 93 bighas. That is
Yes.
what
Yes.
the comment is.
My lord.
Right?
Yes.
If that is so,
Yes.
was it challenged? No.
My lord, I have challenged that, my lord, that this land is my land. This has been wrongly made Sarkari. That is why, my lord, I have filed the application. Till now, my lord, it is going on, not disposal. And now they wanted to. So far, one thing is concerned, my lord, I am giving alternative.
Why he is writing then that you are making prayer for allotment of the said land to?
My lord, that is.
I'm just asking.
My have been, my lord, I do not.
It is not 1 bigha of land, 93 bighas. We have to ask the question.
My lord, here your lordship see. My lord,
Otherwise, the deputy commissioner will not say so
My lord.
in an official letter.
my lord, this letter, my lord,
This letter is of 1990.
16A letter does not say, my lord, that it could be settled in my city.
No. 16A letter.
Yes.
You say that it has been made Sarkari by mistake,
Yes,
right?
yes.
And in that there is an endorsement
Yes.
at page 18
Well,
that by 1970 itself,
yes,
you were writing the letter in 1978.
yes,
But in that there is an endorsement of somebody
yes,
that by an order dated 1911-1970,
yes,
this 93 bighas and so has been made Sarkari.
yes,
Sarkari.
yes,
Then in 1990, Deputy Commissioner is writing to the Commissioner,
yes.
page 18A,
My lord,
that this has been made Sarkari.
yes,
And now your authorities are praying that that land should be allotted to the garden authorities.
my lord,
And they will not, because it is in the Deputy Commissioner is also making an observation that since it is in the midst of the tea garden,
yes,
it will not going to serve any purpose
yes.
for the government. That is what he has observed.
He observed. my lord.
Then he asked for the opinion of the Revenue Department.
Yes,
Then Revenue Department
yes,
made a comment in 1991
yes,
that it seems to be a case of restoration,
yes.
has been in continuous possession.
The circumstances under which the area was made Sarkari are not clear.
Then thereafter what happened?
My lord. Now, yes, my lord. Thereafter, my lord, again, my lord, the page 22. On the above subject, I am to say that a copy of the Sita enclosed total so-and-so land belonging to Gopal Krishna Dish was made Sarkari by the then settlement officer by the order number so-and-so. But no reason for so doing appeared to have been recorded as per a copy of the Sita. The teacher authority has prayed before the so-and-so for restoration of the area made Sarkari to the Leagues, and government has now wanted to know the reason for making the land Sarkari. Since the reason for this was not mentioned in the Sita, we are not in a position to apply the government about it unless a copy of the your order is made available to us. I therefore request kindly punish so-and-so. This is
Then?
the. Now, again, next letter.
Not traceable.
Not traceable.
Not traceable.
Not traceable.
Uthuri Bagisa.
And if your lordship see the Jamabandi, my lord.
I'll
Jamabandi
come to
had-
that. We are going serially.
Yes,
Then in 2015, they issued a notice
yes,
for demarcation and eviction.
my lord.
Okay. Then you wrote.
Yes. We should the various letters. Then we have to come.
Okay.
Now, if your lordship see the additional affidavit filed by me on 9/5/25, for page 54 is the Jamabandi copy.
Page
54, Annexure A. The original is also there. I even the transfer copy.
and that has been striked off
Yes,
by pursuant to that 1970 order.
yes, sir. That is done.
Huh.
That is a question. That is, my lord, done absolutely without authority of law, my lord. That is why government also asked the reason why it has been done.
Now what is the stand?
Now, so far the this is concerned, one tag is not there, my lord. For one tag is concerned, we are.
What is the affidavit?
Yes.
Now, what is your letter? 2/12/2015. $158. A part of it already has been distributed.
15 bighas.
150, Doug number 158. 14 bighas.
14.
In 2016, to 56 landless tea garden workers.
Who's that? Who's that?
And the stand is
150. Number.
it cannot be said that the order of making Sarkari was unilateral in nature. 70. We are 55 years after 1970. This has been made Sarkari in 1970.
But what is the reason, my lord? That is the main question.
Silly land ceiling case is also there, 75 my lords.
75 land ceiling case
That is
is
also
there.
not under challenge, my lord.
No,
This point, my lord, has not raised in any manner, my lord. The source is not challenged, my lord.
that
And this is out and out, my lord, my respectful submission, my lord, subject to correction if my learned friends says so, my lord. This is ceiling surplus land. This cannot be real. That is why, my lord, in the letter, in the communication, DCS said, although there is no provision under the law, as a special case to consider, I have referred to it. That is the, my lord, last contention of the letter of the Deputy Commissioner.
What is the stand of the Revenue Department?
My lord, that is 1990, my lord. 1990, and thenceforth, my lord, this is pending.
That is
before-
only a two-line letter.
My lord.
What
No,
is
my
the
lord, no, my lord, this one, 28,590.
98. No, in this, Deputy Commissioner has filed an affidavit.
My lord.
What
Deputy
is the
Commissioner, my
stand of
lord,
the Revenue Department?
But 91, my lord, page 21.
and as a
Page
special case, since under the present law, no further allotment and settlement of land for special cultivation is admissible.
Which one?
That-
Which paragraph?
My lord, this communication dated 28,590. And my lord, Deputy Commissioner, I also, as directed by this honorable court, also sought for a latest instruction on this, my lord. I can't do that. No, that is also latest position, with a view to know the latest position, honorable court directed, my lord. And it was made during 1997, and thereafter ceiling is 75. Everything has been summarized there, my lord.
Now, how the order making Sarkari is before sealing case?
Yes, perhaps, my lord, under the act that has been done. Subsequently, my lord, sealing case was initiated 75, my lord. Without knowing, my lord, nothing was done, my lord. This cannot be, and my lord, in the pleadings, there is no mention that we did not have any knowledge. Lordship will see, the only challenge here is the notice, my lord, during 2015, my lord.
We came to know in 78, my lord. In
Even
78
78 also, they did not challenge, my lord.
Yes.
Even 2015 also, my lord. They did not challenge it, my lord. Only thing wrongly, illegally, that has been made Sarkari. So my respectful submission before Lordship, my lord, the issue cannot be resolved here, my lord.
What is 187, that number?
Yes.
Total land they are occupying, my lord, I think more than 100 bigas. Another
187.
93 plus 10 biga, my lord.
Yes. So far, one side.
Another area of 10 biga, 5
lesser.
lesser.
Right.
Cover 187 in the district of so. They are also alleging that you are encroaching 10 biga, 5 lesser.
10 bigger I am giving separately, my lord, because I have given alternative land outside the garden, my lord. That is the habitable land. That I have given the affidavit.
That 93 viga, I think, my lord, ceiling surplus, 10 viga is, my lord, out and out government land.
It cannot be ceiling surplus, my lord. Ceiling surplus
If,
land is.
if that is not, my lord, the garden authority could have challenged all these things, my lord.
In 1991, government has issued a letter, my lord.
Yeah, some fixation of land singles now.
1956. And for ancillary purpose also land granted, my lord. Beyond the allotted portion, my lord.
Mr. Goswami,
my lord.
There is an exception in section 2.
My lord. Exception. Yes.
2A. The provisions of this act shall not apply to.
My lord.
2A.
My lord. That 50 vigas cannot be confined in respect of, my lord, this or this special cultivation, my lord.
No, read it. 2.
Yes. 281, my lord. The land held by the state government, union government, or any local authority or by any agriculture farming constituted under the Assam Agriculture Farming Corporation, so and so. It's a government establishment. No? Land held and utilized for special cultivation of tea and purpose of this is not applicable in respect of, my lord, this ceiling 50 viga, my lord.
No, lands held and utilized for special cultivation of
Yes.
tea and purposes ancillary thereto.
Yes.
Ancillary thereto has been explained somewhere.
Yes. And it has been in the letter itself, lordship. Can I read it once again?
Then the proviso. Provided that if at any time such land ceases to be utilized for the purposes mentioned in the above,
yes,
said subclause, the provision of this act shall apply. Otherwise, ordinarily, this fixation of land ceiling act is not applied for
special
Lands
cultivation.
utilized for tea cultivation, special cultivation and ancillary thereto.
Right.
Ancillary part is explained.
Yes.
Now, but if land is found to be
Unutilized.
unutilized,
Then
can
it
be
will go back to the government.
go back to the government. So we don't know
My lord.
in the absence of any record,
Yes.
Mrs. Hayola,
Well,
But my
in
respectful
what manner the
Yes.
sealing case has been done
Yes.
and in what manner
well,
it has
this is covered by tea plantation. This cannot go under.
My lord,
single-
been. So it can go.
Yes.
My lord,
I was also under the impression that it cannot go,
Yeah.
but it can go.
In a appropriate case, my respectful
If
submission.
you
in
trace
my
the
lord,
history, how large
Yes.
chunks of land
Yes.
are given by British,
My lord.
it
Well,
can
they-
go. NLR land also can go. New lease.
no.
Because,
Unutilized land, my lord.
Ah, it is there.
Yes, only so far tea garden, tea bushes and ancillary purpose that is retained, that can be.
No,
So
if
far
that
retail-
provision is there, no,
Yeah.
there was no bar.
Yes,
There was no absolute bar.
yes.
There is a proviso, there is an exception.
Ah.
So rightly or wrongly,
Yes.
it was done.
No, but this is not done. in the
And
ceiling,
my
my lord.
respectful submission is,
Here-
my lord,
here it
in
is not
consonance
done in
with
ceiling,
the,
my lord. That is my question is there. In 1991 also, my lord, the government has issued a letter. Your lordship, page 21.
No, in the absence, how can we decide?
Let them decide, my lord, because as per this also, my lord, this
Who will
also-
decide? The disputed questions of fact.
No, they have to decide. my lord.
There is
Even-
because you remain silent also.
yes.
No,
Without challenging. Is there, was there anything?
78, my lord, even this notice.
We are deciding a case after 55 years.
Yes.
Right? And this factory or this company is in existence since 1970. And they are not highlighting the vital aspects.
My lord,
Why they remain silent?
so they have to issue.
And you continued to pay Toji Bahira land
Yes.
revenue
Yes.
My lord,
regularly,
Yes.
my lord, I have
admitting your position.
position, that is why 78.
You continued paying TB land revenue or not?
I am paying because
Then
they are not taking.
That
regular
is
revenue.
Toji Bahira.
They are not taking regular revenue, my lord.
For
That
occupying
is why.
government land.
That is why, my lord.
You should not have equation to such position.
Let me understand from it, my lord. And moreover, my lord.
You are not a landless farmer. You are a mighty tea
It's
company.
small garden, my lord.
It's not small garden.
More than 1,000 megas.
My lord.
2000 bighas.
Yes.
No, not more than.
Famous cinema was shoot there. Is it not?
Moreover, my lord, now, my lord.
Starring Dimple Kapadia.
As per the division bench, my lord, judgment also, my lord, if any eviction notice is issued, they have to give a hearing clause.
1975, after 1975, even there is no approach.
My lord, the two division bench judgment, two division bench judgment.
Which judgment?
This is the last judgment, my lord, this is the earlier judgment.
Oh, this is eviction.
Eviction. But here, this
But
is,
there is a history prior to that.
no, history, but this is also eviction, my lord.
That is 18.2, that is 15. We have to see to understand this history.
So this is why in 1991, the government has written to them, my lord.
This way or that way, we have to give finality to this
My lord,
repetition.
your lordship must see the page.
We will not
21.
continue today. We will not continue today.
My lord?
We will not continue today.
Yes.
We'll again resume.
Will remain as part of it.
It will be there. Let me clear the other part of matters.
My lord.
কোনে বেছি দিছিলো ফাৰ্ষ্ট ডেটো কিবা দিছো ন ফাৰ্ষ্ট ডেটো কোনোবা দিলো নেক্সট উইকৰ চাই লওক টিউজডে বা থাৰ্ছডে কিবা এটা থাৰ্ছডে দিলো কোনটো থাৰ্ছডে দিলো নেক্সট থাৰ্ছডে
My lord?
নেক্সট থাৰ্ছডে
Well, I shall not be here, my lord.
Tuesday?
It may be 25th, my lord.
I may not be here.
Then later, my lord.
Thereafter, I don't know whether the bank roster changes or not.
Even if it remains as part hard, my lord.
No, I'll not add one more to part hard. That is why I want to make it early.
Today is Tuesday. This Thursday then, my lord.
No, this not this. Tuesday, next is Tuesday, you are not available.
Tuesday.
18th?
No, my lord. Then next week I shall know. So that's it, 25th or 27th month. In December, first week.
Loi na.
First week December.
Yes.
2nd of December.
Lordship.
Since it is 2016 matter. Okay, GN Sahala, Senior Counsel, State by Miss K. Bhattacharya, Land Council Board of Petitioner, Mr. B. Bhattacharya, Goswami, Land Traditional Advocate General, State by Mr. Koli P. Kakoti, Land Council Board of State Respondents are present, sought from agreed to by the Land Council Board of Parties, list the case on 2nd of December 2025.
Crave your lordship's indulgence, my lord, item number 15. Your lordship has fixed it on 18th. My lord, 18th, I have some religious issue at home. Can it be on 20th?
28th?
20th, it's a Thursday.
28th করিব ডিকে বরাজাজি নামটা লিখে দিব
Interim may be continued.
Interim already continued.
Obliged, my lord.
Oh, এখন Mr. Sahela, this document, land deed, please take it back. We'll resume at 2. Yes. Anything?
Yes, your lordship, on the last occasion, peruse the selection committee's report, 5/4/16. In that report, at para 9, page 15 and 16 of my writ petition. My writ petition, paragraph 9.
Paragraph 9.
Page 15. It is stated that due to pendency of the writ petition, they could not select a suitable candidate. But how they then select? Last portion, there is an impediment to the compliance of the honorable court order. And the said writ petition was disposed on 29/5/15. Annexure A.
এটা ফাইল আছিলে ফাইলটো আছে নে তলত নে খেলি মেলি হ'ল
A stand was taken in the affidavit by the CDPO in the contempt case.
My lord.
Thereafter, it was disposed of.
Dispose of, but dispose of that, my lord, annexure peruse, annexure and page 66. It was disposed of on judgment date 29/5/2015.
No, K, Annexure K, 63.
And my
Annexure K, page 63. That is the contempt petition disposed of.
Disposal. But my lord, that my lord, it was the proposal was made on project level 20 that 4614, my lord. Prior to that, my lord, during pendency of the court case, my lord, they have select, my lord. And in the state affidavit, they have stated that.
No, that is project level committee's view. Project level committee's view. This is project level committee.
Yes, ma'am.
9/6/2024 or 14/6, whatever.
Yes, ma'am.
They said that they have they would like to,
Decided to select
they
school
would
of-
like to go with the selection of respondent number 8.
Yes, ma'am. But in the affidavit reply in the contempt case also, they have stated that.
They have said, but court has said that contempt petition closed.
Contempt clause, my lord, prior to that, they have selected.
And this,
And they.
I have
they-
said this order, page 66. Against it, no contempt petition is preferred.
My lord, because they have prepared an appeal, that appeal is still not disposed of. I want to know about that appeal, my lord. The appeal is pending. They have stated that before Commissioner and Secretary, that appeal has been pending since long back, my lord. And in the last order, they have not mentioned anything about in the appeal dated 24/8/2012. In the.
Yes, Mr. Dhar, what
Order
about
dated.
your instruction?
And my lord, I have also a copy of the contempt petition and reply made by them, my lord.
No, it is the end result which is material.
That is, it is in their honor, they have stated that due to pendency of a writ petition, my lord, they could not select a suitable candidate. They
Since
have made
2017,
contract-
everything is okay. Yes.
contradictory statement.
My lord, as regard the records, my lord, I haven't received it. And my lord, the thing is that if I go by page number 66, my lord, the writ petition was filed by the private respondent, my lord. He is trying to take an advantage out of it. If my lord, the private respondent is not aggrieved, she did not file an, my lord, contempt petition.
Yes.
The petitioner cannot take an advantage of my private respondent, so my lord, petition, my lord. And at the end of the day, my lord,
Doctor.
page number 64 is still not challenged. That takes care of everything, my lord. Order dated 24/4/15.
Meaning should be better. $64.
It's writ petition, my lord. It is order. This order is not challenged, my lord. Page 65 is the, my lord, the last para. In view of the aforesaid facts on record, Srimati Puravi Devi is suitable candidate
amongst the candidate who appeared in the earlier interview who has been working in the Anganwadi center in question on the basis of engagement letter dated 16/11/2009 as well as in terms of court's order dated 6/6/13 in writ petition number such and such. And as such in terms of the court's order dated 9/10/13 in writ petition number 4037 of 2012, the CDPO concerned proceeds with the matter and decision has been taken by the virtue that the project level selection committee meeting held on 9/6/14 to select Ms. Srimati Purodevi Devi, a suitable candidate from amongst the candidate who appeared in the earlier interview. Hence, the order dated 9/10/13 passed in writ petition number 4037/12 has been complied with. Meaning hereby, my lord, this rightly or wrongly, my lord, order has been passed. This is 15, we are in 25. 10 years has passed by, my lord, in between. This is not under challenge and writ petitioner is aware of this.
Part of his document.
My lord. It's a part of the, my lord.
Petitioner's document.
Yes, petitioner's document, my lord. And my lord will see in page number 65 last, my lord, a copy is marked to the writ petitioner.
Regarding that, my lord, I have already stated that there is a contempt proceeding. They have stated that due to pendency of that proceeding, they could not select any suitable candidate.
Okay, Likok.
But they have selected again Purobi Devi. This contradict to his paper.
It is noticed that the present petitioner was part of the 5 petitioners in the writ petition, WPC number 5495/2009, within brackets Srimati Goma Devi and 4 others, versus State of Assam and others, which was disposed of by an order dated 3/8/2011, with a direction to the respondent number 2 to examine the cases of the petitioners in terms of the direction contained in an order dated 11/5/2011, passed in a batch of writ petitions, including WPC number 215/2010, within brackets Chitravati Padgiri versus State of Assam and others. Full stop. Pursuant to the order dated 3/8/2011, a verification report was submitted by the respondent number 3 before the respondent number 2 on 3/9/2011. No, on 6/3/2012. Full stop. The respondent number 2, after conducting a hearing with the stakeholders, passed the order on 30/5/2012. Where is that order? 35/2012.
And it's the page 30.
Page?
38. That is type portion. Question को लिखा हमारे
pass the order after recording his tentative findings. On the matter, to place the matter before the project level selection committee for taking necessary action as per the norms and guidelines of the government in force. Full stop. Accordingly, when the matter was placed before the project level selection committee on 21/6/2012, for examination and consideration of the matter for taking necessary action as per the norms and guidelines issued by the government, the project level selection committee resolved that on examination and consideration, the respondent number 8, already engaged as Anganwadi worker, was found to have belonged to the locality where Paschim Kholihabari Anganwadi Center was located. Full stop. However, not taking a final decision in the matter, it forwarded the matter again to the respondent number 2 for his decision with a query whether fresh interview could be ordered. Full stop. When the resolution of the resolution dated 21/6/2012 was placed before the respondent number 2, Supreme Court decision. We need to know. Now, respondent number 2. Taking note of the resolution adopted by the project level selection committee and the liberty granted by the court in its order dated 19/7/2012, passed in contempt case C number 269/2012, passed the order dated 18/10/2012,
in compliance purportedly of the direction given in the order dated 3/8/2011. The respondent number 2 took note of the observations made earlier in the order dated 30/5/2012 and 2 other reports submitted by the respondent number 6 and the respondent number 7. And a report dated 30/6/2012 of the project level selection committee. Poster. By the order dated 18/10/2012, comma, the respondent number 2 had again ordered that the project level selection committee would review the earlier observation taken by it in the light of the order dated 30/5/2012. And would take further action for engagement of the Anganwadi worker at Pasim Kholihamari Anganwadi Center as per norms and guidelines issued by the government.
There is also a reference of that contempt case annexer C. Is potentially.
Don't dictate. What should I dictate? I hope you understand. Already all things are noted. All contempt cases, whatever. We are not supposed to, in my estimation, however, the respondent number 2 on Eight 4/2013 issued an office letter to the respondent number 6 with a direction to select a suitable candidate from amongst the candidates who appeared in the earlier interview for engagement to the post of Anganwadi worker at Pasim Kholihamari Anganwadi Center in consultation with the chairperson of the project level selection committee. Post of. Though in the order dated 8/10/2012, though the direction made by the respondent number 2 in his order dated 8/10/2012, the respondent number 2 had made some
had set certain criteria for engagement of the for selection and engagement of the Anganwadi worker at Paschim Kholiahamari Anganwadi Center, comma, the response number 2 by the subsequent order dated 8/4/2013 had made a specific direction to select a suitable candidate from amongst the candidates who appeared in the earlier interview for engagement to the post of Anganwadi worker at Paschim Kholiahamari Anganwadi Center in consultation with the project level selection committee. Post of. By the order dated 8/4/2013, the purport of the order dated 8/4/2013 of the respondent number 2 was to select the suitable candidate amongst the candidates who appeared in the earlier interview held on (6/10/2009). Post of. It is pertinent to mention that the Child Development Project Officer of the concerned block is the authority who engages the Anganwadi workers in the Anganwadi centers within his area of jurisdiction. He is the appointing authority.
Yes, sir. He is there.
And the respondent number 2 and the Director of Social Welfare Assam is not the appointing authority of the Anganwadi workers, right?
Right. Right.
Gusto. After the order dated 8/4/2013, it was the present petitioner who instituted the writ petition WPC number 4037/2013, praying for an appropriate direction to the state respondents to take action in accordance with the office letter dated 8/4/2013. So by such action, on the part of the present petitioner, seeking compliance of the direction made in the order dated 8/4/2013. Comma, the present petitioner had clearly foregone the had clearly foregone to pursue the matter in terms of the direction made in the order dated 3/8/2011, Supra. So rather, comma, the petitioner, present petitioner, acquiesced. ACQUEICED. এই পাঠটো লাগে। Acquiesced with the direction made in the order dated 8/4/2013. Posto. The court, in view of such submission made on the part of the present petitioner in WBC number 4037/2013, and comma, disposed of the petition WBC number 4037/2013 by the order dated 9/10/2013, directing the respondent number 6 to proceed with the matter in accordance with law pursuant to the office letter dated 8/4/2013. In the Black's Law Dictionary, comma, 9th edition, comma, the meaning ascribed to acquiesce is to accept tacitly or passively, colon, to give implied consent to, within bracket, quote unquote, an act, and to acquiescence is a person's tacit or
passive acceptance, semicolon, implied consent to enact. It will. Next paragraph. It has been observed in a decision of the Honorable Supreme Court of India titled UP Jal Nigam and another versus Jaspant Singh and another, reported in 2006 11 SSC 464, acquiescence does not mean standing by while a violation of a right is in progress, but assent after the violation has been completed and the person has become aware of it. Full stop. It is unjust to give such a person a remedy where by his conduct, he has done that which might fairly be regarded as equivalent to a waiver of it, semicolon, or whereby his conduct and neglect, though not waiving the remedy, he has put the other party in a position in which it would not be reasonable to place him if the remedy were afterwards to be asserted. Acquiescence means an implied consent to an act. Thus, when acquiescence takes place, it presupposes knowledge against a particular act. Full stop. From the knowledge comes passive acceptance. Therefore, instead of taking any action against any alleged refusal to perform the original contract, despite adequate knowledge of its terms, and instead being allowed to continue by consciously ignoring it, and thereafter proceeding further, acquiescence does take place. Once such a situation arises, it is not open to the party that acquiesced itself to insist upon compliance of the original terms. Hence, what is essential, is the conduct of the parties. When the required exercise was not carried out for a period of time, it was the present petitioner again who instituted a contempt petition, contempt case C number 213, 2014, alleging non-compliance of the direction made in the order dated 9/10/2013. Full stop. When it was submitted before the court on 23/2/2015 that the required exercise would be carried out and completed within a period of 3 months, the court closed the contempt petition by an order dated 23/2/2015. Reserving the liberty to the petitioner to file a fresh petition for contempt if the order was not passed within a period of 2 months.
Full stop. Flows on the hills of the oh, para. It was prior to 23 to 2015. A meeting of the project level selection committee was held on 9/6/2014, wherein the matter of selection of a suitable candidate to the post of Anganwadi worker at Pasim Kholihamari Anganwadi Center in terms of the direction made in the order in the office letter dated 8/4/2013 and in compliance of the order dated 9/10/2013 was considered. First off, the project level selection committee, after a threadbare discussion, verified the applications which were submitted by the candidates, the records of the earlier interview process, and the comparative statements so prepared. First off, the project level selection committee had unanimously decided that the respondent number 8, who was engaged as Anganwadi worker earlier, was found suitable amongst all the candidates who appeared in the interview on 6/10/2009. Post op. Taking note of the order passed in WBC number 2710/2013, the project level selection committee decided not to issue any fresh engagement order to the respondent number 8 as she was already discharging her duties as Anganwadi worker in terms of the earlier order of engagement dated, what is the date? 26/11/2009. It was subsequent to Nine 6/2014. Meeting dated 9/6/2014. Nine six. It was subsequent to the resolution dated subsequent to the order dated 9, no, it was in consideration of the order dated 9/10/2013, passed in WPC number 4037/2012, semicolon. The resolution taken by the project level selection committee in its meeting held on 9/6/2014 and the order dated 23/12/2015, passed in contempt case C number 213/2014, the response number 6 examine the records of the selection process for the Anganwadi worker at Paschim Kholi Hamari Anganwadi Center once again. Full stop. The response number 6, in compliance of the direction made by the response number 2 in his office letter dated 8/4/2013, to select the suitable candidate from amongst the candidates who appeared in the interview held on 9/10/2009, agreed with the decision taken by the project level selection committee on 9/6/2014 to the effect first of it stands it needs iteration that in its meeting held on 9/6/2014, the project level selection committee took an unanimous decision on the basis of the relevant records, interview performance, inquiry reports dated 29/11/2012 and 4/1/2014 of the jurisdictional circle supervisor and the earlier meetings of the minutes of the meetings of the project level selection committee, held on 21/6/2012 and 25/1/2013, reached a finding, concluded that the response number 8 was found suitable amongst the candidate who appeared in the interview. First of, the response number 6 also considered the application forms submitted by the candidates, more particularly, the residence certificates issued by the concerned Gambura, as well as the survey register of the Anganwadi Center area. Full stop. It was after such examination and consideration, the response number 6 recorded his findings in the order dated 24/4/2015 in the manner, already extracted in paragraph 22 above. The respondent number 6 had observed that the order dated 24/4/2015 was passed in compliance of the order dated 9/10/2013 passed in WBC number 4037/2012. Full stop. The learned counsel for the petitioner has made a submission that it is due to non-disposal of the appeal preferred by the respondent number 8 before the respondent number 1 and the operation of the interim order dated 29/5/2015, comma, the order dated 24/4/2015 could not be termed as a order attaining finality. Full stop. The order dated 29/5/2015 was passed in WPC number 2710/2013, comma, a writ petition instituted by the respondent number 8 and not by the present petitioner. Full stop. After the order dated 29/5/2015, comma, the respondent number 8 appeared to have not filed any case alleging non-compliance of the direction to the respondent number 1 to dispose of the appeal within a stipulated period of time. Within the stipulated period of 1 month from the date of submission of a certified copy of the order. Full stop. It is not known whether the respondent number 8 submitted any certified copy of the order dated 29/5/2015 before the respondent number 1 for disposal of the appeal. Full stop. It is true that if such submission of the certified copy of the order dated 29/5/2015 was not submitted by the petitioner or respondent number 8 before the respondent number 1, the respondent number 1 would have no occasion to dispose of the appeal. And order regarding restraint to take any prejudicial action against the respondent number 8 would have lost its force. Full stop. As no material in this connection is available in the case record and no submission has been made in this regard, comma, no further observation is required to be made on such count. Full stop. Reverting back to the prayers made in the said petition. It is found that it is noticed that the petitioner has sought for a writ in the nature of mandamus for directing the respondent authorities, more particularly, the respondent number 2 and the respondent number 6, to act on the basis of the orders dated 3/5/2012. Post of 30/5/2012. Post of. From the discussion made above, it is noticed that the petitioner, by an act of acquiescence, had herself insisted for compliance of the direction made in the order dated 8/4/2013, for which the petitioner pursued, for compliance of which the petitioner pursued the matter through the writ petition WPC number 4037/2013 and the contempt petition, contempt case C number 213/2014. Full stop. Therefore, the said prayer in the considered view of this court does not have any force for a petitioner to insist. Full stop. It is settled that it is a settled proposition that an order which is not challenged in a petition cannot be set aside and stroke or passed by the writ court. Full stop. The order dated 24/4/2015, the respondent number 6 had selected the respondent number 8 as a suitable candidate amongst the candidates who appeared in the interview on 6/10/2009 pursuant to the advertisement dated 7/9/2009. Full stop. In the order dated 24/4/2015, the respondent number 6 had also recorded the satisfaction that the respondent number, the residence of the respondent number 6 was found to be within the area of jurisdiction of Paschim Kholihamari Anganwadi Center on the basis of the reports submitted by the number of authorities mentioned above. Mentioned therein. Full stop. The copy of the order dated 24/4/2015 was sent to both the present petitioner and the respondent number 8 for their information. Full stop. The present petitioner the present petitioner has chosen not to challenge the order dated 24/4/2015 despite making it a part of the pleadings. Full stop. Para. The respondent authorities made a number of inquiries. The state, the departmental authorities made a number of inquiries through a number of authorities for ascertaining the residential status of the respondent number 8 in order to find out whether the residence of the respondent number 8 was within the area of jurisdiction of Paschim Kholihamari Anganwadi Center. Full stop. A reference of those inquiry reports have been made in the order dated 24/4/2015 passed by the respondent number 6. Full stop. The matter of determination of the residential status of the respondent number 8 is a fact-finding exercise. And the court, exercising the power of judicial review under Article 226 of the Constitution of India, does not embark into any fact-finding exercise in respect of such matters. Full stop. Para. It is also worthwhile to mention that the subsequent to the order of engagement dated 26/11/2009, the respondent number 8 has been continuously serving as the Anganwadi worker at Paschim Kholihamari Anganwadi Center for last about 16 years. Full stop. In such view a matter, no further inquiry is called for. Comma as sought. No further inquiry, comma as sought for by the petitioner in the instant writ petition, comma is called for. Huh? Ramsar 16 years to Ramsar, huh? Last about 6 years. For the from the discussion made. In view of the discussion made, no. In view of the discussion, above discussion, comma, for the observations made therein and regions recorded, assigned. Observations made and the regions assigned therein, comma, this court finds that this writ petition is bereft of any merit to interfere, merits of any merit. Full stop. This court does not find any reason not to speak of any good reason, comma, to interfere with the order of engagement dated 26/11/2009 made in favor of the respondent number 8, when the respondent number 8 emerged as the first rank candidate with first set candidate amongst all the candidates. Consequently, the writ petition stands dismissed. No order is to come. No. Yes, Mr. Upadhyay. One liner.
Only 5 minutes.
One liner. Just what is the case?
It's a
We'll not
case.
hear. What is the case?
The case is a land acquisition matter.
What happened?
And here the land acquisition, land has been acquired
So filed.
by the National Highway. And
National Highway. Then
yes,
what happened?
then compensation is fixed as 2 lakh per biga, 1 lakh per biga. Then we approach the arbitrator.
3G5.
Yes. Then the arbitrator fixed it 15 lakhs per biga.
Good.
Then they preferred appeal
34.
34. Then that has been reduced to 5 lakhs.
Okay.
But here the important question is that there are many landowner, only 2 landowner gets the compensation.
Okay, you have to first address then.
Yes.
Section 34 petition is to be preferred before a court.
Yes. Section 34 preferred, but only they have made the party
1 minute.
1%.
Preferred before a court.
Yes.
Right?
Yes.
If it is court, the order is passed by the court.
Yes.
Right? Normally it is 37.
Yes.
Ordinarily. What is the ground of challenge?
We didn't receive the amount. So we were.
You want which one? Passed by the court or passed by the arbitrator?
Passed by the arbitrator.
That has been set aside.
No, they have not made as party in the appeal.
Even then, one issue you have to address. No order of a court can be challenged in a writ petition under 226.
No, I am not challenging the order.
No. What?
5 lakhs I have accepted.
You have accepted?
Yes, we have accepted the 5 lakhs.
5 lakhs?
Yes.
Then, Mr. Borua, you are not paying.
5 lakhs, we have paid, no?
No.
Not me.
Only 2% get the.
We'll look into it because we have, according to my statements, I have a affidavit detail, I have affidavit I have gone through. I have filed affidavit.
How many petitioners?
34.
These petitioners.
The petition.
You take
It is-
instruction.
it
Whether
is
you-
Actually, what happened, my lord?
Now tell me whether you have paid or not. If you are,
No,
they are agreeable to 5 lakhs.
No, here, according to me, just hasn't. We have.
So Supreme Court has said we should not be relegated as an executing court.
Yeah.
Because for execution, then you have to go to the execution court.
I don't know, statement, yes.
Mr. Upadhyay,
But
if you are satisfied with 5 lakh,
we are satisfied to 5.
then you should have approached the execution court.
But here, we have not made a party in the appeal.
No, in which way you want to challenge? In which way you want to challenge?
I should get the 5 lakhs per region.
If that is so, just for facilitation, otherwise we are not executing court. And Supreme Court has said in highway matters also, convention matter, don't entertain writ petition. But anyway, Mr. Borua,
My lord.
please take instruction. Whether the petitioners who are beneficiaries of award are paid the commission amount or not. After the order passed under section 34 of the Arbitration and Conciliation Act. That is your case?
Yes.
Heard Mr. N.N. Upadhyay and counsel for the petitioners and Mr. C. Burwal and standing counsel
NHA,
and
2 and 3.
AI for the responding authorities. Post of Mr. Burwa is to obtain instruction as to whether the petitioners who claim to be beneficiaries of awards passed under National Highway Act 1956, have been disbursed the compensation amounts after the order passed under section 34 of the Arbitration and Conciliation Act 1996. Right?
Right.
Challenging that lordship, they have approved the district judge. And district judge has reduced the amount to 5 lakhs.
That is what I said. It is the district judge.
So
Already
they
I
are-
have
they are
already I have held that or Supreme Court. I am not saying.
No,
I am
but
just
they are not challenging that order of the district judge. They just want that, okay, we want that 5 lakhs.
still that is also not.
Lordship.
Supreme
They
Court
have-
has repeatedly said, don't relegate the High Court under 226 to an executing court.
Lordship.
Don't entertain writ petition with an observation. If you entertain this kind of writ petition, you will be flooded with thousands of writ petitions. I can show you the order right now, I do not have, but still to facilitate, since it is pending for 2022, had it come before me, I would have dismissed the motion still. Take your instruction.
We approve the district judge court.
No, this may be applicable.
Please the case on.
Last judgment will help me. Your lordship just now passed.
Lease the case on.
January.
Not
No, because.
money.
No, that's
in
correct.
the
December will, he's also not available. I'm also from 13th onwards, I'll be not available.
Prior to that,
Yes,
Prior to that, I cannot hear lordship.
prior to that, I can.
we will get the information only.
1 to 15.
It is up to you then. Lease the case after 4 weeks.
After?
4 weeks.
Like.